Hey all, moving to a new topic this week. We just did the 5-part piece series, and now I'm going to kind of jump around and hit on some different parts of the family law practice area that we spend a lot of time here at the law offices handling. One of the areas that we have quite a lot of work in is injunctions or restraining orders. You may have heard those phrases used sometimes interchangeably, an injunction or a restraining order. So I wanted to explain what those are, the different types there are, what the courts require for you to get one, what sort of protections it affords you, and that sort of thing. So in Florida, we have 5 basic types of injunctions. We have domestic violence injunctions, we have repeat violence injunctions, we have dating violence injunctions, we have sexual violence injunctions, and finally we have stalking injunctions. So one of the most common types of injunctions that we deal with here in the office is domestic violence injunctions. So that's where somebody that's either a family member or somebody that lives in the household has committed an act of violence upon the person seeking the injunction. So Florida statutes define violence, and it doesn't just have to be a battery. It can be an assault, it can be stalking, it can be that sort of thing, kidnapping. These are all forms of violence under the statute. So if someone who lives in your household or is a family member has committed an act of violence against you, and you have a reasonable fear that there's an imminent threat of danger by them, you can seek an injunction from the clerk of the circuit court. Depending on which county you're in, you can go down, fill out the packet. It doesn't cost you anything. And usually what happens is that same day that you fill out the packet, the clerk will hand it to what we call the duty judge. On any given day at the courthouse, there's a duty judge who reviews all these petitions and determines whether or not they're legally sufficient for an injunction to be granted on a temporary basis. So if you go down and have filled out your petition for injunction and the duty judge has said, yes, this is legally sufficient, a temporary injunction will be issued, and it will be transferred to the sheriff to serve on the respondent or the person you're trying to take the injunction out against. The statute then says that they have 14 days to bring the case back in front of the judge for a return hearing. At that return hearing, what the judge will do is hear testimony and evidence to determine whether or not a permanent injunction can be granted. And there can be permanent injunctions for 6 months, a year, 3 years, or permanent, and actually for any duration there between. So domestic violence are one of the most frequent ones that we deal with. Another one is repeat violence injunctions, which are a little different. A repeat violence injunction is where the perpetrator isn't a member of your family or doesn't live in your household, neither of the two. And there's been at least 2 acts of violence, the most recent of which is within the past 6 months. So this could be someone, a neighbor, someone that you know from school, from work, whichever. If they've committed 2 acts of violence and the most recent one was within 6 months, then you may have a basis to get a repeat violence injunction against them. Sexual violence injunction is basically just that. If you've been the victim of any kind of sexual violence, it doesn't matter how recent the act is, it doesn't matter the number of times it happened, it doesn't matter whether or not the perpetrator lives in your house or is a family member. If you've just been the victim of sexual violence, that alone is a basis for you to go and get an injunction. And then finally, and this is one that is becoming more common for us that we deal with due to the computers, the advancement in computers and social media, etc. And this is stalking injunctions. So stalking injunctions are a little bit more nuanced. For stalking injunctions, you need to either show that someone is following you, harassing you, or cyber stalking you, and that there's a course of conduct over a period of time. So following, that's basic. If someone's following you repeatedly, that's the following. Cyber stalking, if someone's using text message, social media, email, electronic means to repeatedly interfere with you, then that may be a basis for a stalking injunction. And then harassment. And so harassment talks about there must be a course of conduct that's willful, repeated, malicious, that serves no legitimate purpose, and that causes substantial emotional distress. So there's a lot of moving parts there. One of the ways that this comes up a lot in my family law practice is oftentimes spouses who are estranged or after they've become divorced still are involved in a back and forth with each other, whether they're not happy with how the other parent is dealing with their children, or maybe the spouse is now with a new person and they interfere. You can't just show that they're contacting someone over a course of time. You have to show that it serves no legitimate purpose other than to harass that person. And then you also have to establish that there is substantial emotional distress. And that prong of the burden on the moving party is one of the most overlooked. You can't just say that they're annoying. You have to show that this behavior is causing you emotional distress. So either you're in therapy or it's manifested itself psychologically or physically in some fashion. So these are the 5 types of injunctions that we have here in Florida. And usually where we come in is in one of 2 ways. Oftentimes someone will call us and say, we've had an injunction filed against me. Can you help defend me against that injunction? And we do that sort of work. And then the other type is where someone says someone is bothering me or has committed an act of violence on me. I would like to take out an injunction against them. So in those circumstances, what we'll oftentimes do is we'll have them come into the office and we'll sit down and help them draft what we call the narrative or the story or the reason that they're looking for the injunction. They'll then take that down to the clerk, fill out the packet, file it, and if it's granted, at that point then we come on and represent them seeking the injunction. These are quite common. They also happen a lot as kind of simultaneous cases with our family law cases. A lot of times when there's some sort of fight or argument going on in the household, you might find that one of the parties takes an injunction out on the other party. Sometimes with good cause, and other times done for more nefarious reasons, like gaining leverage in a family law matter. So it's important, if you're involved in an injunction, either as a petitioner or as a respondent, to have an attorney who knows what the elements are for each of these types of injunctions, and that way they can adequately represent you and help you either obtain the injunction that you're seeking or defend you against the injunction that someone's trying to take against you. Hope this has been helpful. I look forward to talking to you guys next week. Thanks.